Yes, Lord Lady, before the short adjournment, I was taking you to the Civil Service and Ministerial Codes. There's just one paragraph I also to draw your attention to in relation to that. It's perhaps not necessary to turn up. It's paragraph 17 of the Civil Service Code, which says, if you become aware of actions by others which you believe conflict with this code, you should report it to your line manager or someone else in your line management chain. Alternatively, you may wish to seek advice from your nominated officer. You should report evidence of criminal or unlawful activity to the police or other appropriate authorities. So it's a follow-on from the point that was made in relation to paragraph 16 about if you have a concern. It's perhaps rather stronger when there's a complaint of unlawfulness.
Is the ministerial code that you've shown us, which is signed by David Cameron, the one that we should be looking at, has the substance of it remained the same? Is it just the forward that changed?
There is in fact a reference in some of the earlier documents to one of the lawyers warning that action might be in breach of the ministerial code, and I think it uses the same language.
Right.
Yes, it's Appendix 5, page 3137, where, and this was in relation to the policy in the very early days.
Page
3137.
So, I mean, it may well be that all that's changed is the forward. Would that be right, of the ministerial code?
I'm sorry.
The ministerial code, the only thing that's changed is the forward. Because my point was...
Yes, that's right.
We didn't understand that you were relying on that.
I'm not in a position at the moment to say what the one was that was enforced. No doubt Mr. Beloff can say if there's been a material change, but it's certainly something that was well in the mind of the legal advisors at the time, because at page 3137, in relation to detention of persons pending deportation there, what Mr. Bravin-Roman said, who was one of the Home Office legal department officials, if ministers or civil servants who are aware that any person is being held unlawfully sanctioned continued detention, there'd be real issues under the ministerial and civil service codes.
So which paragraph is that?
It's paragraph 7.
But that is, the reference to 1.5 is certainly not to the current.
No, the numbering clearly seems to have changed. But but there is, again, unsurprisingly, an overriding duty to comply with the law.
What slightly puzzles me in all this is there's no sign of the law officers. I mean, the Home Office has got an absolutely top-rate team of legal advisors, and the Home Office legal advisor is almost at the very top of the tree. And I would have expected, if there was all this worry within the Home Office as to the legality of policies being followed by the department and so on, that they would have consulted the law officers on the matter. It's a very strange thing.
As far as I'm aware, there's no reference to that even being suggested.
Well, it's very curious.
Yes. And also, and again, I'll be corrected if I'm wrong, there was a report, an internal report, conducted by Mr. Wood himself, which makes a number of recommendations, but again, I don't think there's any reference to the law officers.
They're very noticeable by their absence.
No, indeed.
It's really extraordinary.
They might even have gone to Treasury Council.
To whom almost certainly the law officers would be.
Well, there are references to certain discrete points having been taken.
To council, yes.
Exactly. But the kind of concerns that are being raised here on a widespread scale, well, we don't know. We have actually there has been correspondence about whether privileges have been waived in those matters, but it's not really profitable to go into that at this stage.
I mean, Mr. Gursky, I don't want to run any more hairs than we need, but I mean, if all these contentions of yours are made good, I mean, why isn't this misfeasance in a public office?
It could well be, but it's... sorry. Yes, Mr. Same reminds me that it's not actionable per se, although I think it has been held that deprivation of liberty is an injury for the purposes of misfeasance. It may well be that the reality is that all these matters have emerged in the course of these proceedings, which indeed is part of the appellant's complaint about lack of candour. It's possible that if all of this was known earlier, then the case might have been framed rather differently. But it was framed. One sees when one looks through the chronology of the pleadings. This starts off as a routine Hardle Singh claim, and then it grows in the telling. But if I can come back to the material that I want to show the court, and I will be as sparing as I can, given the time and given the volume of material. What I will do, as I've indicated, is go through following the points that are set out in our new submissions. And if I can start then with the hidden blanket policy, which is, I suggest, a significant starting point, really for the reasons I was endeavouring to develop earlier on. That there is, so far as patent illegality is concerned, and so far as the responsibility to bring proper legal advice to ministers and officials is concerned, a clear difference between a presumptive policy, which is something on which, as the debate today has demonstrated, is a point on which different views can be held, and a blanket policy, which everybody knows is unlawful, and which undoubtedly deprives the detainees of the individual consideration to which they're entitled. Now, the Court of Appeal found that there was a blanket policy in place for those who weren't caught by Cullen, those who weren't caught by the Cullen criteria after November 2007. And of course, as they pointed out, the number of people who were likely to be caught by the Cullen policy was very small indeed, because it's not necessary for me to take you to the schedule of offences that were excluded from consideration there, but they were so comprehensive, or rather, I think it worked the other way around, that those are the offences that you would be considered for. But the nature of Cullen was so narrow, in effect, that it would exclude almost anybody who'd committed an offence serious enough for them to be imprisoned.
Is this Cullen 1 or Cullen 2?
Well, both Cullens, because the differences between the Cullens isn't so much to do with the pool that's eligible for consideration, it's to do with the factors that block your release. And so Cullen 1 had particularly a problem that you had to have a sponsor before you could be released, and very few of the detainees did. And it also had requirements that where the difficulty on returning you wasn't actually personally your fault, but was to do with difficulties with the Commission or Embassy, then that also counted against you.
Cullen 1 was November, wasn't it?
Cullen 1, yes. I mean, the staging post here, the policy, or the scandal, as it were, breaks on 25th of April 2006. And then on the 5th of May, Charles Clarke is replaced by John Reid. And both Charles Clarke and Dr. John Reid made statements to the House, and the blanket policy started at the point in April, on the 25th of April, and between 2006 and 2007, really in 2 blocks of time, you have a position where officers are trying to draft a policy that will meet ministers' concerns. But they've got a problem, at least in the first part, which is that you can't draft a lawful policy without it being a policy that provides for somebody, at least, to be released. And the clear message that one gets is that ministers simply won't accept that, or in relation to a memo emanating from the Prime Minister's office, they won't buy it. I'll take you to that. And so those proposals come to nothing in 2006 because the feeling is that ministers won't accept them. They then get revived in 2007. The next staging point, as it were, is that on the 28th of June 2007, Dr. John Reid is replaced as Home Secretary by Jackie Smith.
What was that date?
28th of June 2007. And at that point, a proposal is put to the Home Secretary. But again, on documents that I'll show you, she doesn't take it forward at that point. And the memos that she, or the message coming from her office, is to the effect, why are we concerning ourselves about this now? Has anyone brought a claim against us? And she then doesn't take the point any further forward. And eventually, what happened was that because of severe overcrowding, the proposal was represented. There was a letter from Jackie Smith to the Prime Minister on the 19th of September 2007, which again I'll take you to. And that eventually became Cullen 1, which came into effect on the 8th of November 2007. And as I've indicated, that was extremely restrictive, and hardly anyone was released under it. I think in the interviews it suggested there were only 3 releases under Cullen 1. And that, because it was so ineffective and the overcrowding difficulties continued, that policy was then changed in March 2008, which led to Cullen 2, and it was Cullen 2 that was eventually disclosed on the 1st of April 2008, again in circumstances that I'll come to.
And the name Cullen comes from the official who was drafting it?
Where does it come from? We don't know. There are lots of people drafting this, and none of them are called Cullen. So it's the
all-purpose name.
I see.
And then what happens is that on the 9th of September, there's a new policy that you've seen, and which I think there has been a bit of confusion at some stages about whether that's a publication of Cullen or whether it's something else. I think it's now clear that it wasn't a publication of Cullen, it was a publication of a rather different policy, which was to do with a presumption of detention in respect of foreign national prisoners. And while I'm on this point, can I take the opportunity to qualify what was said yesterday about that policy by Mr. Hussain, and whether it superseded Cullen. The position is that these proceedings have been conducted on the basis that that is so, but the applicants and those who instruct them aren't in a position to know what's happening, or whether Cullen or something like it is in fact still being applied. And so we don't invite the court to make any ruling on that. But equally, the applicants and their advisors don't want anything they say here to prevent them taking a point at a later date that Cullen or something like it is still being adopted or applied. But certainly these proceedings can be conducted on the basis that Cullen was superseded by the September policy and now, of course, the 2010 policy. So those are the main staging points in the chronology, but it's also perhaps worth noting that during that time, again, as I think you saw yesterday, there were 2 variations to the published policy, which simply maintained the presumption of release. One was in August 2006, and the other one was in March 2008. Moreover, what happened during this period was there was a test case that went to the Court of Appeal, Abdi, now known as A Somalia, which I think you may be hearing about tomorrow, or later on today, and that was clearly an opportunity to bring to the court's attention what was happening, but it wasn't taken, and there was no publication at that point. So those are the main points in the chronology, and I'd ask the court to bear those in mind when we go through the documents to see where things fit in. And if I can start then with the first point about the nature of the blanket policy. And of course, when I say blanket, we don't say that absolutely nobody was released, because we know there were, I think, some 15 releases on compassionate grounds. They're scheduled to Mr. Wood's statement. But what certainly didn't happen was that anyone was released on Hardal Singh grounds. The Court of Appeal held that post-Cullen 1, 2007, there was a blanket policy for the people who applied, to whom Cullen applied, but they said there was an inconsistent practice before then. There was a difficulty with that finding because everybody agreed that the reason for introducing Cullens 1 and 2 was to relax the situation that was happening. Nobody was getting out, and then some people got out when Cullen was introduced. And therefore it follows, really, simply as a matter of inference, that if there was a blanket policy in respect of the people to whom Cullen didn't apply after Cullen, then there must have been a blanket policy before Cullen. And that's simply an inference that the Court of Appeal ought to have drawn and didn't draw. But equally, that the new material before the Court of Appeal very clearly demonstrated that certainly as far as the most senior officials were concerned, and in fact the Home Secretary was concerned, there was a policy which precluded release being applied. And the material that shows that is a document that was disclosed very shortly indeed before the Court of Appeal. It's in Appendix 2B at pages 1613 to 1615. And it's a document redacted from the Home Secretary, you see her signature at 1615, to the Prime Minister, headed bail proposal for foreign national prisoners. And the proposal is to take forward proposal for lower risk FMPs, making it easy for the agency to swiftly deport more easily removable FMPs. Then it says, in addition, no one convicted of a violent offence will be eligible under our plans. Then it sets out the justification for the proposal, and over the page, having quoted from Bob Whaley about the volatile mix in the current population in the BIA estate, says, and this is the next paragraph, by currently having no discretion to grant bail, the BIA has regularly to transfer FMPs around its estate. So it's quite clear that no discretion to grant bail. And then under legal position...
Sorry, where does it say that last bit? I'm sorry, it's my fault.
It's the second paragraph on page 1614.
Okay.
And then under the cross-heading legal position, the proposal on bail is also driven by a necessity to ensure we stay within the law when detaining FMPs. Since April 2006, the BIA has been applying a near blanket ban on release regardless of whether or not removal can be achieved and the level of risk to the public linked to the nature of the FMP's original offence. And then 2 paragraphs further down, we now face a number of pending legal challenges. And at the bottom of that page, to address this risk, we need to introduce a policy of detaining more selective FMPs once consideration of deportation has been completed. We'll also continue to ensure there's no change to our current position in keeping high-risk FMP offenders in detention pending their deportation. So what's being suggested is a proposal which, although it's going to allow some releases, is going to make sure that the remainder remain in detention. Now, I take you to that document for 2 purposes. Firstly, to demonstrate the high level of knowledge that there was about the nature of the policy. And although it's nowhere near as stark as some of the material one sees elsewhere, there's a clear knowledge of the risks involved, the legal risks, in adopting a policy of this kind. But it's also significant, highly significant, I suggest, in relation to the complaints that the appellants make about non-disclosure and lack of candour in this case. And I can make that point really by putting this document in context and how it emerged. The position of the Secretary of State has always been, throughout this litigation, that she has complied with her duty of candour. In a letter of the 19th of August 2008, references Appendix 1A, page 810, it was suggested, it was asserted
Sorry,
that...
can you give me that citation again, please?
Appendix 1A, 810, it was asserted that they had fulfilled their duty of candour, but then 2 months later, on the 22nd of October, page 826, the respondent revealed it was still conducting a search. And in fact, it turns out that search hadn't started until the 28th of September 2008. And we found out shortly before this hearing, by a letter of the 20th of September 2010, that the person conducting that search, and the person responsible for determining what documents were relevant, wasn't somebody from Treasury Solicitors, as one would have expected, particularly in the context of this case, where there were, from the outset, or certainly once the Cullen was revealed, there were grave concerns about whether there had been full disclosure. It wasn't someone from Treasury Solicitors, but the team was headed by someone called Zilla Bowell, who was the Deputy Chief of Staff in the Chief Executive's office, and she'd been appointed to the task by David Wood. And the material pointing into all of that is one of the more recent letters. It's in Appendix 5, 3031. I won't take you to these documents because it'll take a long time to chase through the paperwork. But that's
Is this all written down somewhere conveniently for us to have? Or,
there's a...
I mean, I've read these appendices, but is that sufficient, or are you wanting us all to write down a lot more?
The best place that you can find all of this is in the most recent submissions, which are the ones at the beginning of Appendix 5. And so the page reference for that is page 3015, which sets out the concerns about the latest disclosure.
The beginning of the...
Yes. If I can explain what this note is. Shortly before the hearing before this court, at the end of October 2010, some 5 files of documents were delivered to the appellant solicitors by Treasury Solicitor, apologising for their late disclosure, but saying that these were documents which they were disclosing on a in effect a without prejudice basis, without prejudice to their contention that they had fulfilled the duty of candour. On looking through those documents, it became clear that there were a number of things that the appellants wanted to draw out of them, and that's what led to this note. Without asking you to go through it all now.
I mean, how does this note relate to the very full Appendix B?
It's if one goes to the 3018, where it says contents of latest disclosure, one can see that it sets out what the latest documents show, that there are really 2 categories of relevance. One is documents indicative of the blanket practice, which is the point I'm addressing now, and secondly, documents indicative of the knowledge or recklessness of the Secretary of State's senior officials. And then those are particularised later on.
By latest disclosure, it's you're referring to what we see in Appendix 5.
That's right. Yes, you obviously don't have all 5 volumes, but we've extracted the ones which.
But there's been nothing since then. This is so. That
exactly.
appendix is based on that.
The documents in Appendix 5, 5 from tab 5B, are selections from the new material, and we make no bones about the fact that they're selections that we've made without, and the respondent may want to suggest there are other documents that aren't in there, but we gave them an opportunity to do that, but they didn't take it up. And
these then could be interspersed with the annex of your case to
they could
chronology. How much work would be involved in doing that?
It could probably be done fairly quickly.
It would be helpful, I think.
And they could, I think, be reproduced in that form, because Annex B took the story up to the point when it was drafted, when there hadn't been any further documents since the Court of Appeal. But it could certainly be updated.
That would be helpful, and maybe if they were put in italics so one can identify the most recent discovery.
Yes, well, we can certainly do that. We can add in, and what you will have seen when one goes to Annex B is that there are documents are flagged up as when they arrive.
Yes.
And certainly we can do the same thing
Yes.
with the latest disclosure. And we will.
So you'll give us a new Annex A and B, will you?
Yes, we'll give you a revised Annex B. I think Annex A probably won't need any revision.
Very well.
Well, it's Annex A to the case. There are a number of appendices, but what I'm referring to is Annex B of the case. The one which, yes, it's.
Well, it's called Annex 2, rather tardily.
Yes, I think it started as Annex B, and which is why the references, I think.
But they're all B paragraph numbers.
Yes.
Correct.
Yes, I was placing in its context the letter from the Home Secretary, and I've taken you to the points about the disclosure, but the position as it was before the Court of Appeal was that the Secretary of State's case remained at that point, that this had been a presumptive policy throughout. That was the case they'd put before Mr. Justice Davis, and despite the fact that he'd had some misgivings, he accepted that the various references on the documents that he had before him, although they appeared to point towards a blanket policy, weren't in fact evidence of a blanket policy, and they were in effect occasional references. That was appealed, and for the court's note, the relevant part of the skeleton argument below is at Core Volume 2, pages 303 to 315. And
Pages again,
303 to 315. And if I can ask you to take up the Core Volume to look at the way in which the point was dealt with by the respondent. And it's pages 345 that we need to go to. 345 is where the skeleton starts, and the relevant passages are at pages 360 to 361. In fact, if I can ask you to start, in fact, page 357 rather than 360. And what the respondent said there was, it's accepted that there are some contemporaneous documents in the evidence which, when read in isolation, are consistent with the operation of a blanket policy. And it then refers to the appellant's skeleton. If these are read in isolation, they might provide a basis for a finding that blanket policy was being operated. However, it's readily apparent that these isolated observations weren't intended to be a complete statement of the policy that was being operated. They came in the context of short, informal emails and discussions in which it was not necessary to describe the detail of the policy that was being operated. So what's being suggested is that the various references are anecdotal. And the respondent contrasted that with what they said was the superior evidence that they had at page 360 to 361, which is just as the appellants can point to isolated anecdotal references to a blanket policy being operated, the Secretary of State can point to contemporaneous correspondence between senior officials that shows the mere presumption was being operated. And then they refer to an email from Mandy Campbell to deputy directors on the 21st of December 2006. And that, I think, is footnote 3 in the Secretary of State's case. It seems, we've never seen a document of the 12th of December, but it seems that footnote 3 is intended to be this document and that the 12th has been wrongly transposed to the 21st.
So you say that's the 12th?
Well, no, this is the right date.
I see.
The footnote's got the wrong date. And what it says is the Home Secretary has been very clear in his statements that there'll be a presumption of detention in all FMP cases that are removed.
So the email should be the 21st of December.
The email, exactly, yes. I think that's right, and it's... And this document comes at the end of an email chain, which I'll show you at a different part of these submissions. But that's what the Secretary of State was relying on. They were contrasting the informal, anecdotal, low-level exchanges with what they said was a higher-level email that demonstrated a presumptive policy only. This skeleton argument was dated the 25th of November 2009. On the 27th of November 2009, which was a Friday, with the hearing due on the following Monday in the Court of Appeal, the defendant disclosed the document I've just shown you from the Home Secretary, which demonstrated beyond any doubt that this was a blanket policy, and demonstrated beyond doubt that that was known at the level of the Home Secretary, and one can't get more senior than that. And of course, it was a document going from the Home Secretary to the Prime Minister. And the appellants say that there's absolutely no reason why that document should not have been disclosed earlier when Mr. Wood made his statement on the 31st of October 2008. And indeed, no explanation has ever really been given as to why it wasn't disclosed. I understand that in the Court of Appeal, the suggestion was made that it was, as it were, more of the same. But it critically undermined the claim that the policy was presumptive only, and it demonstrated that the true nature of the policy was known at the very highest levels within the department. And there is no explanation to this day as to why that was withheld until such a late stage before the Court of Appeal. And it goes further than that, because Mr. Wood himself, who had made the statement exhibiting the documents on which Mr. Justice Davis relied, must have known that his statement was incorrect, because minutes of a meeting at which he was present on the 9th of June 2008 were also disclosed. In fact, they were disclosed in error, although it was later said that they had been included on a list.
So they said what?
There were minutes of a meeting dated the 9th of June that were disclosed, which have Mr. Wood quoted as saying, DW, that's Mr. David Wood, was clear that the policy had been to detain all time-served FMPs and that something additional, Cullen, was needed to prompt any release. That was a document which, as I've said, was disclosed in error and which you will find in Appendix 2B at pages 1820 to 1. This is referred to in the Appendix B to our case, so I'm not going to take you to references that are there. It's... I don't know, sorry, it would be quicker to take you to the document. It's at... But, my Lord, I'll give you the reference to that.
Could you give me the reference in 2B then?
Yes.
Okay. Sorry, I didn't know.
We'll give you the reference in the updated version.
When was it disclosed?
The document from the Home Secretary.
No, the minutes.
The minutes were disclosed in November. They were November 2009.
And why in error?
It was a tranche of disclosure that didn't include this document in the list attached to it, and it's accepted in the Statement of Facts and Issues at paragraph 186. At paragraph 86, that was an error.
There's a reference to the June meeting at page 144 in the appendix. It doesn't actually quote anything from it, but it refers to it. There's at page 144, B95, little 6. And is it...
Well, this is obviously a false economy. What I'm going to do is take you to the document. It's
Actually, it's B58 quotes it. I think that's the best reference.
Yes.
What's the reference?
Thank you.
What's the reference?
The reference in the document is page 1820 to 1, and it's in Appendix 2B.
At B58. B58.
And B58 is the appendix in the case.
Yes.
I'm sorry, what page in 2B?
1820.
It's the very bottom of that page, isn't it, that you're
That's right.
referring to?
And it's the second paragraph up from the bottom. I don't propose to take up time taking you to further examples as to why it is that the statements put in the courts below were clearly misleading, apart from one point I'll come to later on. But it would... can I draw the court's attention to a schedule in Appendix 5 at pages 3319 to 3323. And this is a document that was produced before the Court of Appeal. And without asking you to go through it point by point, what it does is it sets out in 3 columns the points which or the findings that the appellants sought, the material in relation to those which was in the respondent's statements, and comments on those. Unfortunately, this has been copied in such a way that the headings that make that clear simply haven't come out. This was intended to be a better version, but it came out worse. But what I would suggest, if the court is content with this, is that at the same time that we do the amended Appendix B to the case, we produce another copy of this, which has got legible headings, but is also updated to the current bundles. As I say, rather than take up time going through now when we have to chase through the bundles, we'll do that, and we can get that done, I think, overnight. So that's the material that I want to draw your attention to now at this stage about the blanket nature of the policy. There's a lot of more material in Appendix B, but I'm not going to take you to it. There's a point that follows on from this, which is the point that I mentioned when going through the main staging points in the chronology, which is the difficulty that Home Office officials had in trying to formulate a policy that was acceptable to ministers, but at the same time stayed within the law. And they started doing that in June 2006. There were a series of drafts that the policy went through, and they used various formulations to describe what was happening. The ones before Mr. Justice Davis talked about detaining all FMP cases as a matter of course, and that was thought not to be tenable for much longer. The reference to that is in Appendix 2A, 1018 to 1020. Later versions that had been through the legal department strengthened the reference to whether the position was tenable for much longer. They simply said it wasn't tenable, and suggested that the current position ran a high risk of being unlawful.
So what was the reference to that?
It's in Appendix 5, 3150. And it might be worth looking at that. And this is a version as amended by Nicholas Samuels, who was in the legal department. And exactly where this one. We know where this one. But it seems to be a finalised draft, but we still don't know exactly where it went. But what one can see is that it says, Foreign National Prisoners Policy on Detention, we're currently detaining all task force and flow criminal cases where it's decided to pursue deportation. This is contrary to our published policy on detention and runs a high risk of being unlawful in some cases. This submission proposes a change of policy in relation to criminal cases so that our criteria for detention explicitly refer to the need to protect the public. And then in paragraph 5, in recent weeks to maximise public protection, We've been detaining all task force and flow criminal cases where it's decided. We've also been opposing grants of bail. We do not think this position is tenable. Under primary legislation and case law, we have no power to detain those for whom there's no realistic prospect of removal within a reasonable period of time. The key country-specific issues are around routing, documentation, and cooperation with source governments. And where we can detain, we need to be considering any exceptional circumstances which might count against detention in court-recommended cases, and actively considering whether deportation is appropriate in line with our published policy in non-conducive cases. And so this then went on to propose a change in policy, and one sees that paragraph 11, such a policy would be likely to lead in a small number of cases release subject to a restriction order, and so it goes on. Other drafts in the same vein suggested that if they brought the current practice into line with the published policy, then they may have to release a substantial number of FMPs, and in fact, one of the documents suggested 150. So the blanket nature of the policy had a real impact, as it was understood by the people responsible for it within the Home Office, and they knew that it might well lead to a significant number of unlawful detentions. And it's in this context that a memorandum was sent from Lorraine Rogerson, who was head of policy for the Borders and Immigration Agency. And this is the document to which reference has been made to allowing judges to take the hit for releasing people on bail. And you'll find that in Appendix 2A at page 1068. And we can see it's an email that goes to a number of people, including Ken Sutton, who is the Deputy Director General. It's in anticipation of a submission being made the following day, and also in anticipation, it seems, with a meeting that Lynn Homer, the Chief Executive, is due to have the following Monday, the 24th of July. We've asked but don't have notes for that meeting, but one sees that it was due to take place from the penultimate paragraph over the page at 1069. It's quite a long memo, but the points that I invite your attention to are at paragraph 3. We're currently detaining all FMPs without regard to existing IND published criteria. A number have been released on bail by immigration judges. It asks for the figures. And then says, lawyers are digging about with FOIs about our criteria and guidance, so we're increasingly vulnerable. And then paragraph 5, paragraph 4 says we should probably publish revised criteria, and then paragraph 5 says, we suggest we should review the criteria and consider being prepared to release in some cases, with public protection as a priority, for example, where there was no violence involved. And then there's square brackets just after the parentheses saying, but Ken, that's Ken Sutton, thinks it's highly unlikely that ministers will want to release in any cases of FMPs, particularly with regard to the Public Accounts Committee report to be published tomorrow. And then 6, we should elaborate on non-FMP releases, which might produce more of a risk to the public, and why and how many. And then it asks data, and there's a point about tagging policy. And then the last 3 lines says, even then, ministers' preferred position may be to continue to detain all FMPs and let the immigration judges take any hit, which is to be had by releasing on bail.
And presumably you would ask us to consider that in the light of the Civil Service Code, which requires not only that civil servants comply with the law, but uphold the administration of justice.
Yeah, absolutely, and also to give impartial advice and not to withhold inconvenient facts. This is the sort of thing that this obviously isn't advice to ministers, but it's in contemplation of a meeting with them, and it is in effect tailoring things to what ministers want to know or want to hear.
Is it? Where do you see that?
Well, it's the bit about the Ken thinking it highly unlikely that
Oh,
ministers want to
that's
read it.
realistic. I mean, that's what he knows, what the ministers are going
No,
to say. I mean, it doesn't mean to say they're not going to tell them that. They just know that if they're told that, they're going to say, well, we want to stick with the policy and let the immigration judges take the hit, as it.
Well, there are other documents that suggest that documents don't go up for exactly that reason.
Can you tell me, this is for the submission tomorrow, submitted to whom?
We don't know, do we? It's one of the things that we don't know on the document.
Because the language minister's preferred position may be, would not be inappropriate if one were preparing a document to be submitted to ministers.
Yes, it looks like what was happening. That there are two. This is the 20th of July was a Thursday. There was going to be a meeting on the Friday, which is the meeting tomorrow. And then when you go to the last two paragraphs over the page, it says, Ken has said Lynn will want to have discussed our position and agreed it before the meeting with ministers on Monday. So there was going to be a meeting with ministers on Monday the 24th. And we've asked for the notes in relation to that meeting, but they haven't been given.
And this kind of correspondence usually culminates in a submission to the appropriate minister.
Well, indeed, we'll see what happened, because it's what was going on at this stage. When you go to page 1071, is that one of the things that the officials wanted to know was, well, what's the impact going to be? How many people are actually going to be released? And so they asked for modelling information. One sees on 27th of July 2006 an email there asking for statistics on three varying scenarios. One is we apply our published policy, i.e. presumption towards release. B, we apply revised detention policy, that was the draft, i.e. no presumption towards release. And then C, the current position, i.e. blanket detention. And there are various emails going backwards and forwards about the difficulties in producing modelling information. And it's also in this email chain that one has, and it's while we're in this group of documents, the email at page 1088, which is to do with a discussion about whether it's a legal or policy presumption in favour of release. And Mark Owen, who is the author of that email, says, and it's the fourth paragraph down, given this and the fact that the immigration detention is prescribed in law, I can't see how this would not override any Magna Carta rubbish.
Who is Mark then? Owen Mark?
He's the policy lead of the CCD. Lord, the last draft in this group is on the 18th of September 2006 at, and it's 1156. I don't need to take you to it. It avoids explicit use of the language of policy presumption. It didn't go any further at this stage, and it's something that Mr. Justice Davis noted in his judgment, but then didn't really comment on it and wasn't really in a position to comment on it. But we can now see what happened. That there's the message from Ken Sutton, that it won't go to ministers because they won't be interested in any releases. And then on the 5th of July 2006, in one of the documents disclosed as part of the new disclosure, Mark Owen writes, and the page reference is 3153, and he's raised a query with the legal department, and then writes back saying, OK, my interest is really just in being as tough as we can be on FMPs. Ken's currently holding back the submission because he thinks ministers will think we're going soft and wants to re-examine the language I've used. It's page 3153 on Appendix 5.
At the top.
And the fact that this is, as it were, the reason why the submissions aren't made to ministers is in fact clear from the report of Mr. Wood, which the appellants cite at their paragraph 251, it's page 97 of the case. And it wasn't a passage that found its way into the Court of Appeal's judgment.
Of the case.
And what Mr. Wood recorded was the Deputy Director at this stage indicated he didn't think recommendations made would meet ministers' requirements, and policy colleagues were pressed to consider alternatives, which didn't appear to undermine the ministerial imperative to protect the public. Ministers' requirements for FMPs not to be released had been very clearly communicated in meetings with the most senior officials in IND, and they were therefore certain that a policy which might lead to the release of any FMP would be highly controversial with them.
What date is that, Mr.?
We don't know. It's a passage from the report of Mr. Wood, and one of the difficulties with the report is that he doesn't tie things into specific documents. One can often work out what he's referring to, but it's quite oblique.
And where's the document?
It's paragraph 36 of Mr. Wood's report, and the report starts at page 1904. In Appendix 2B. And paragraph 36. Page 1918, 15
So page what?
Page 1918. And he's talking there about the time frame. You see this in page 1917. The time frame June to September 2006. So it's the period that I've been addressing.
Deputy Director was Mr.
Sutton.
Sutton.
And so
the paragraph you were referring to?
It's paragraph 36 of the report, page 1918, and that's where the quote in the appellant's case comes from.
And that, sorry, the period you said it related
The period, if you go to the preceding page, 1917, the way the report's set out is it goes through in
Yes.
broad chronological blocks. And this is the June to September 2006 block.
If we can have 46 volumes of authorities, why can't we have a chronological bundle of documents?
The bundle is the bundles 2A and 2B are chronological.
Yes, but there are others.
But the difficulty with the Appendix 5 is that it came so late
Yes.
that the appendices had already been done. And obviously, if it had come at an earlier stage, we'd have put them in the usual way. Yes, it came on the 29th of October this year, so we have had just about 3 weeks to deal with them.
But will your Annex B, I mean, it'll obviously flesh out to include all this material,
Yes, it will.
and it would be very helpful if it was A, in chronological order, B, of course, it'll indicate when various bits of it were disclosed.
Yes.
But it might usefully append, in chronological order, the documents there referred to in the schedule.
That would be, we can certainly do that. At the moment, Appendix B is done more thematically than chronologically, but if the court would find it useful to have a chronological working of the same material, then we're certainly happy to do that. I can't promise to get it done overnight, as I was promising.
I have a recollection, I may be quite wrong, that there was a request that we should postpone the hearing because of the late arrival of the material. Am I wrong about that?
It didn't come from us.
No, not from you. At any rate,
It may have been canvassed at some point, but I don't think the point was ever made
right,
to the court. But
I mean, speaking for myself, I would have thought chronological, covering all these various aspects, because they all interrelate as to how you were trying to put up a policy and this and that and that.
Absolutely, and it's really within the confines within the Rooks and Barnard formulation that it's been done in that way. But I can see that a chronological pattern may be maybe easier to follow. And we can certainly produce a document along those lines. But as I say, it's going to be difficult to do it very quickly.
The basic theme seems to be all too apparent just from Annex B as it stands, namely that the department didn't want to disclose the softening of the blanket policy because of the press and the adverse political publicity, and they didn't want to disclose the hardening of the policy because of the legal challenges.
That's certainly what happens when you get to, when the policy does get softened in Cullen. There's a clear decision
Absolutely.
not to publish. And what's going on at this stage, which is some time before Cullen, this all goes on for a year before Cullen, you have the officials grappling with the difficulty of not being able to put a lawful policy to ministers, because ministers won't accept it.
The point that my Lord Brown makes surely comes out very clearly in Mr. Sutton's email or note on page 1158, where he begins by saying, he says it doesn't work for two reasons, and then he talks about the juxtaposition, which I think is exactly the dilemma which Lord Brown is drawing attention to. 1158. This is where he turns down their draft submission.
That's right.
Which is, I think, what is being referred to in paragraph 36.
That's right. That's the last.
Yes, and you see here the juxtaposition of saying that on one hand we need to change our published policy to make it tougher in detention, on the other we need to change our practice in detention to make it less tough. It simply does not work.
Exactly.
Which is Lord Brown's point.
Yes, well, what that's also alluding to is the problem that the department presented itself with after Cullen had been drafted, which is that it simply doesn't make sense to put into the public domain a policy that says we are now relaxing our criteria, because when you read that together with the published policy, the question is why? If you're applying the published policy, why do you need to have something that relaxes it? And it may well be that Ken Sutton is alluding to that as well. But if I can follow through quickly with two further references on this. As the judge found, in September 2006, these policy drafts run out of steam. They get revived at the beginning of 2007, and they are, around that time, there is a prime ministerial stocktake that takes place on the 30th of April 2007. And in advance of that stocktake, Lynn Homer had a meeting with the Prime Minister, and in advance of that meeting there was an email sent, which is at 1352 in the same bundle, Appendix 2A, and it's heavily redacted, but we get the sense from the part of it which is there, which is, and he will not buy any proposals to let people out. I assume that's what your risk-based strategy means. As you know, this is still a very high political priority.
Where do we find that? At 1352?
It's page 1352. It's an email from Alex Martin, whose email address is number 10.
What was the basis of the redaction?
We don't know. It's something which, this is how the document came to us. And then at 1374, what happens following the meeting is there's an agreement to try and work up some proposals. And at 1374, there's a draft being presented, and Rod McLean, who was the head of criminality policy enforcement and compliance, attached a submission at the bottom of the page. It says, at present, I put Ken's name on the top, given his previous close involvement in FMP issues, and the fact this is going to need very careful handling with Liam and the Home Secretary. And this is the document which, at page 1375, was the one which contained the passages which were rightly, we suggest, criticised by the judge. And that it sets out various, it sets out a summary, similar to the one we've seen with some variations. And then at option 1 it says, our current practice of detaining almost all FMPs pending deportation leaves us open to legal challenge, because our published policy on detention states there will normally be a presumption in favour of temporary admission or temporary release. And then it says, about 6 lines down, we could wait for a legal challenge to highlight the inconsistency between our practice and policy. Legal advisers consider we'd lose. We would have to release some FMPs as a result. In this scenario, we could present any change in our approach as having been forced on us by the courts. But we'd have no control over the timing of such challenge, and the longer we delay, the more likely it is that a court judgment would force us to pay out significant sums in compensation to unlawfully detained FMPs. Now that is obviously an extremely disturbing proposal to be put in the first place, but it's as revealing also for what it shows about what was troubling the department, the appellant suggests. That, what was troubling the department, or what was in their minds about the risk of a legal challenge, that they were prepared to view completely with equanimity the idea of having a decision quashed or being subject to criticism by the courts. That was something that they were prepared to take the risk of, and indeed they could turn it to their advantage and present it as a publicity victory. But what they were concerned about...
I doubt if they were the very first government ever to take that line.
Well, it's as Mr. Justice Davis pointed out in his judgment. It may be politically astute, but it's a deplorable approach nonetheless.
Commonplace, I would say, in certain contexts.
But in this context, where what one is concerned with is a policy which is known to be running the risk of unlawfully detaining people, to have that kind of cavalier attitude and say, well, it doesn't matter. If we have to present ourselves as being forced to release this unpopular group, then we can make advantage out of that. But what they're concerned about is having to pay compensation. That's the thing. That's the risk that is flagged up as being the sting in the tail of possibly losing legal challenges, and that the appellants say is a very telling when it comes to consider the potential liability for exemplary damages, because what you have here is a department that is prepared cynically to disregard legal rights, but the thing that it is concerned about is the prospect of financial compensation being awarded against it. And it points very firmly in the direction of suggesting that only an award of compensation would do to vindicate the purposes of the law. This isn't an attitude that's confined to lower level officials. It's also entirely consistent with what happens.
He's a high-level official.
Well,
Mr. Sutton.
Well, we don't know what happened to this memo.
Certainly, it was meant to be for a high-level official.
Absolutely. In fact, this did come to the attention of Ken Sutherland. But what one had later on, when this policy was finally submitted to the Home Secretary, and I can take you here to the appendix to our case at B51 to 3, at pages 131 to 2. What eventually happened was that a proposal was worked up to send to the Home Secretary, and it was sent as a draft by Lynn Homer to the Secretary of State on the 13th of July 2007. And the Secretary of State wrote back through her private secretary saying, Is this an issue primarily about legal vulnerability rather than capacity? If so, what's the reason for worrying about this now? Have we been threatened with legal action? And there were then a series of emails that culminated in the internal legal department writing saying, in my view, there's an ongoing legal vulnerability in this regard. It could materialise at any point almost. If it did, we'd face a liability in damages as well as severe criticism if it was said we maintained a policy of detaining people which is unlawful, as opposed to a lawful policy and just getting it wrong on the facts from time to time, which is inevitable. The response then came back, it's set out at B53. The Minister was of the view that there doesn't seem to be a strong enough or immediate enough reason to be releasing or not detaining people at this point.
Sorry, where is that?
It's the final two lines of B53. So the question is this a legal problem? If so, why bother now? It could blow up at any time, not a strong enough reason to go forward now. And that's from the Home Secretary.
What should the reference be on the bottom of that page in paragraph 54? Seen above at what paragraph? It's obviously not B54.
It is B12.
Thank you.
Now, the Court of Appeal...
Just before you go, what was meant by capacity? Jurisdiction and power?
That would be the size of the estate and,
Yes, that's right.
getting
Yeah.
overcrowded in the...
Yeah.
Oh, that kind of capacity.
Yeah.
Yes.
Yeah.
It's, what was happening at this stage was, and I think it may not be at this stage, but there were, certainly in the course of 2007, disturbances at detention centres.
Yes.
And there are memos that refer to the particular difficulties that there are in managing this part of the detention estate.
So the suggestion is that the Home Secretary would have taken capacity problems more seriously than legal problems.
Indeed, and without taking you through the documents now, what then happens is, in effect, the proposal is repackaged in that way. And that's, in effect, what opens up what eventually becomes Column 1. It's... At this point, it might be useful to look at what the Court of Appeal made of this. All of this material was before them, and substantially the same submissions that are being made before this court were made before the Court of Appeal. But no express findings were made on any of this material. Various references were made. What the Court of Appeal did, and it's core volume Part 2, page 19 onwards.
Can you give us the paragraph? Because most of us, I think, are working from the report on the weekly.
Yes, it's paragraph 35. I'm sorry, my Lord, it's paragraph 39 of the judgment. It's paragraph 13.5 of the internal pagination. What the report talked about, and this is paragraph 35 of the internal pagination, if I can, it says, throughout this period, operational managers and director of CCD were expressing a desire to work within legal frameworks.
Sorry, which paragraph in the weekly law report?
It's paragraph 39 of the Court of Appeal's judgment.
Yes.
And what paragraph 39 does is
Yes.
quote at the length from Wood.
Quite.
Starting
Yes.
with paragraph 20.
It's just above 40, isn't it?
It is just above 40, yes. And there are various references, or there are references here to expressing a desire to work within legal frameworks and so on. A number of meetings to discuss the requirements of constant detention policy which reflected practice. And so that there are references to some concerns about legality, but they do nothing, I suggest, to really capture the weight of what was being expressed internally. and the Court of Appeal simply didn't grapple with that. I should point out at this point that there are two errors that seem to have crept into the Court of Appeal's decision. If one goes to the paragraph immediately above paragraph 35, there's a line that says, legal advice continued to be clear that detention needed to be in line with public policy. That's a quote from Wood, but it's an incorrect quote. The actual quote should be in line with published policy.
Sorry, is this 35 of the Court of Appeal's judgment?
No, it's 35 of Wood, it's 39 of the Court of Appeal's judgment, 35. It may have been corrected in the weekly
Sorry,
reports.
yes, I got it, yes.
It may have been corrected in the weekly reports. I don't know.
Published
But
policy, yeah.
it should say published policy.
It does,
That's
yes.
It does say published policy. Well, that's
Yes.
the meaning is slightly different in the version.
Yes.
And then at paragraph 39, and again it may be different in the weeklies, it says Mr. Wood referred to an advice from counsel. I don't know if that's still what it reads.
Yes.
In fact, it's not an advice from counsel. It's another submission, and the internal reference.
Sorry, I've lost you. What was that
It's
correction?
paragraph 39. It's paragraph 40 of the Court of Appeal's judgment, where it says, in paragraph 39 of this report.
Yes.
I see.
It says, Mr. Wood referred to an advice from counsel of the 18th of September, and then it appears to set out at bullet points the advice. It's not in fact an advice, and when one goes back...
What is it?
It's another one of the submissions in this chain of submissions, and the reference is 1155 to 7.
A draft submission?
It's a draft, yeah.
You say, I think you said there were no express findings, but paragraph 45 in the Court of Appeal does seem to have some kind of a conclusion. It's not very short. That's as far as they go, is it?
Yes, and what they're addressing there is the question of the blanket policy, and that's where I started on my submission, saying that they made a finding about post-November 07, which was necessarily read back to pre-November 07. But certainly what they don't do is make any findings about what legal advice was brought to the attention or within the department, what was done about it, why nothing was done about it, all the points that were raised as very significant factual issues going to the question of exemplary damages. And the Court of Appeal simply don't grapple with that. What they do is set out this material from the Wood report, and of course that report, what was an unsafe foundation, we say, for any fact-finding, because firstly it was produced by somebody who was directly under criticism, and secondly its function wasn't a fact-finding function, it was a forward-looking document.
Well, they do have regard to what the judge said.
They do.
When you come to paragraph 121.
That's right. They recite what the judge said.
This is where we find, and you'll say, no doubt, it doesn't do justice to the case at all. It's very brief, etc., and doesn't take on board many of the points you're making. But this is where we have to go to find what they said and what they made of it.
No, indeed. They express agreement with what he says, and then encapsulate that by saying that there was a failure, which, to put it very mild, indeed was very regrettable, on the part of the department to face up to the basic problem the published policy hadn't caught up with a much more restrictive approach. And that's really the heart of it. They say that the failing was a failure to catch up. They hadn't written down yet what they were doing. And that simply doesn't capture the problem, which is that they were being put in a position of operating a blanket unlawful policy that, because it was blanket, was unlawful, and for that reason simply couldn't be written down. As they understood, and that really was the problem that was facing the officials in 2006.
I mean, the whole thrust of the Court of Appeal's judgment seems to be on the basis that the unlawfulness was not because it disregarded the Hardiel-Singh principles, but on the contrary, that it took account of an adverse, unpublished policy in conflict with the published policy.
Well, that was certainly the way that the Court of Appeal analysed the legal issues before it, because both the blanket nature of the policy and the unpublished nature of the policy were before it. And when they came to consider the main part of the challenge, in effect they held that because it was an inconsistent, or the application was
Absolutely, but there's no, I
inconsistent.
can't find anywhere in the corporate done any hint, that the blanket policy actually is contrary to Hardiel Singh. Where does it say that?
They don't say that. What they say is that they describe it as the finding is at 45, where they say it's a blanket policy. And the reason why I emphasise, contrary to Hardiel Singh, is that a blanket policy might imply that there are no releases at all, whereas it's common ground that there had been 15 releases over this period, but none of them were to do with Hardiel Singh. And when one looks at the documents that describe the policy, they appear to talk about it in Hardiel Singh terms. And so, when one talks about a blanket policy, it's in effect a shorthand term to cover a policy which fetters consideration of any Hardiel Singh type principles and will only envisage release in the most extreme compassionate circumstances. And the circumstances in which releases did take place were exhibited to.
Well,
Mr.
we
Woods.
know they were pregnant women and the rest of it. They weren't Hardiel Singh cases. No, but all I'm saying, and in a sense, it's surely a point in your favour, is that, the court appeals simply don't seem to be recognising that the illegality was not that the unpublished adverse policy was worse for these people than the published policy, but actually that this overrode Hardiel Singh principle.
Well, absolutely. It's a point we make in our case that that was when one comes to consider the failure to publish, it's one thing, as Mr. Justice Davis found, that if there's a presumptive policy, or a policy that everyone understands as a presumptive policy, that there's a degree of muddle in catching up, because there's room for two views about whether that's lawful. But if it's a blanket policy, which everyone agrees is unlawful, then there can't be any question of simply waiting for the time to publish it, because that time will never come. And so I agree with the Lordship that paragraph 122, that the key finding simply isn't reconcilable with a blanket policy.
Again, jumping back to where we were a little while ago, but the reference to 18th of September 2006 and advice from counsel, I think there does seem to be an advice, page 1154.
I'm sorry, I didn't make myself clear that there had been an advice.
Yes.
Counsel advised, I think, on the 15th of August and the 15th of September.
Yes.
But the document, and so when one looks at Mr. Wood's report, what he says is the submission, which is set out in the Court of Appeal's judgment, followed an advice from counsel. Yeah. And so there had been advice at that point. We don't know what the content of that advice was.
No, but counsel clearly cleared the policy which was in the draft which was being put up, which was being suggested, and which was then knocked back by Mr. Sutton on the grounds that it was contradictory.
I don't want to start speculating about what advice was given by, because the documents are equivocal about what was done, and it certainly doesn't seem to suggest that there was a direct authorization of the.
No, but it doesn't suggest that that this document was being put up without any regard to the legality of it in September 2006, because they're saying, well, look, you can put this up because counsel says it's all right.
Well, that document didn't go up.
No, I know it didn't, but all I'm saying is at that time they weren't acting in disregard of the law, it appears.
Well, they were, because the policy that was being adopted was these are proposals.
Put it to counsel, would this be all right?
I'm not suggesting that the officials weren't conscious of what their legal obligations were and were trying to formulate a policy that would comply with the law. But the point is they were in a position where for practical political reasons they couldn't do that, because if they came up with a policy, then it would that was lawful. Then they couldn't get it past ministers, or at least that was what they thought the position was.
Fear was, yes.
Yes.
Can we identify which
was the policy document that was put to council?
I don't know, I'm afraid. We know what came afterwards, but I don't know.
It must be the one which we find at over the page at 1155. Because that was the one, the submission, because its suggestion is that it's going to put this submission, this will be the submission for Mr. Sutton to put up. And then Mr. Sutton says, I'm not going to do that because the ministers won't buy it.
So what page was this?
1154 and following.
Appendix 1A.
Policy 55.
Is there a reference to council here? Can you actually see that?
Yes, confirmed.
Yes, my lord, there are indications to the contrary in the transcripts of the interviews that took place before Wood. And before I say anything more about that, there's a point I need to make, a procedural point, which is that we remain subject to an undertaking in respect to those transcripts, not to refer to them in open court without the leave of the court, and I apply for that leave. I don't know what the respondent's position is.
I don't need to. I don't want to press it further. All I was doing was saying that if one looked at that, it did look as though they'd been taking advice.
Well, my lord, I'll leave it in this way. I'll give you the page reference to the transcript. So it's page 1970.
Sorry, say that again, please.
Page 1970. It's the last answer given by the interviewee.
I don't want to follow this, but on what terms have you been supplied with the transcripts?
They were supplied again. I think the last working day before the Court of Appeals hearing. 2 days before. I'm sorry. They run to some 200 pages, and on terms that I've just described, that we shouldn't refer to them in open court without the leave of the court. And so what we've done in our appendix is endeavour to flag up the interviews in italics, so that, and I hope I've been careful not to refer to them so far, but they really have to be taken as read. I can't, I think, leave 1155 without drawing your Lordship's attention to 1154, which does suggest that the understanding of Mr. Owen, who wrote that memo, was that the policy would pass muster with council. But that the policy would pass muster with council. I put it that way because we don't know exactly what the position was, whether it, and I'm not intending to probe that any further. Also, what I've done so far is really run together the first two heads of the points that I intend to take the court through. The next one is one I hope I can take rather more swiftly, which is that the respondent actively discouraged disclosure of her true detention policy or practice, and the integrity of written reasons for the detention was compromised. And the material in relation to this is set out pretty extensively in our Appendix B, and it starts at B18, page 121 of the appendix. But it's helpful also to cross-refer this to the decision of the Court of Appeal, because this material seems to be the material that the Court of Appeal relied on via the Wood report for its conclusion that before November 2007 there was not a blanket policy but an inconsistent understanding. And the reason I say that is that when one goes to paragraph 41 of the Court of Appeal's judgment, it refers to Wood paragraph 45, Wood, paragraph 45 says, during this period, it's clear that the policy on the detention of FMPs was inconsistently understood by caseworkers, since there was nothing clearly written about it to instruct them. And then it refers to a manual, and we don't know quite what happened to that and whether it was ever delivered as a training document. But then it goes on and refers to evidence of continued concerns from operational staff about the basis on which FMPs are being detained post-sentence. And then it talks about an email chain in December 2006. And then goes on to talk about concerns being raised by staff at Gatwick's removal facilitation unit in January 2007. Now, those are the references that one finds at B18 onwards. And so B19 seems to be an email from about a visit to Liverpool, saying the detention issue was raised again. They've been applying the existing detention policy strictly to the letter, releasing people on bail when there's no immediate prospect of them being removed. We had a long and deep discussion to ensure they're aware of the approach and how it should be applied. But as they rightly point out, it's not currently in the written guidance. We're in danger of an unlawful detaining a considerable number of FMPs. So that was the point being raised. And it's in that context that one gets the email that was relied upon by the Secretary of State in the court below of the 21st of December 2006. Home Secretary has been very clear that there'll be a presumption of detention in all FMP cases. So it's a response to people who are applying the correct policy. In effect, it's saying, don't do that, you should take the tougher line. And that's the point which is raised at paragraph 46 in the Wood report. And then on the 27th, in January 2006, 2007, there was an issue raised at Gatwick Removals Facilitation Unit, where a CCD manager wrote that he sympathised that there was a query being raised about someone being detained incompatibly with Hardal Singh, but he'd been given very clear steer instructions from ministers that were to detain all foreign national prisoners. And then the response was, or the email chain continues, saying what I want written evidence of is the lawfulness. I'm sorry. B21. I'm sorry. B21 is the internal review finding, and the email chain itself is somebody saying what I want written evidence of is the lawfulness of detaining those nationalities we're not able to remove. I'm aware there's unrest in CCD about the power and law to retain some of those held if they're not removable. And then there's a response saying we shouldn't be dealing with this or any such policy discussions in email. I believe a meeting would be the most profitable way forward. The references there are in Appendix 2A, and I won't take you to them. But then if one goes on to B23 and B24, there is an email exchange there where there was a case raised, it's B25, where none of the reasons for detention on the detention letter are valid. And it says we could cite, you're likely to abscond if given temporary admission or release. Well, it's a long email chain. I won't take you through it, but it ends at B31 with Gareth Lloyd, who is the Assistant Director of CCD, saying, we just detain as instructed and choose the most defendable option, in our opinion. Now, what that pattern seems to suggest isn't a pattern of uncertainty or inconsistency or difficulty in understanding. Caseworkers know exactly what they're being asked to do. It's just that they have difficulties with that and query it.
I thought we were on a different topic. I thought we were on your third question, whether the Secretary of State actively discouraged...
No, indeed we are. There are really 2 points here. One is that this is the evidence about discouragement and compromising the integrity of reasons. The reason I link it to the Court of Appeal is that the references that I refer to here seem to be the very same references that the Court of Appeal refer to support their finding of inconsistency. But that's all I want to say about this third point. And then I come on to the fourth one, which is the deliberate decision not to publish the hidden policy. And I've perhaps said much of what I want to say on that already. Both courts below considered that there was no deliberate failure to publish or intention to keep the policy secret. And of course, it's implicit in that formulation that if there had been, then it might well be the kind of case justifying an award of exemplary damages. And that's clearly right, because whatever meaning is given to the term law for the purposes of an obligation to publish the policy, government by secret rules inconsistent with a published policy in this way is bound to be arbitrary and is bound to mislead the courts and parties and all those who are not privy to the policy. But the appellants say that the benign interpretation given by the Court of Appeal is simply incompatible with the material they had before them. And the points I rely on are these, that firstly, even before Cullen, caseworkers were instructed to use misleading descriptions. That's the exchange I've just looked at. Secondly, when Cullen was produced, it was decided not to publish it because it wouldn't make sense read together with the published policy. It's something which is referred to expressly in the Wood report in a passage cited by the Court of Appeal at paragraph 42 of their judgment. I don't need to take you to it. There is a reference at B78 to what caseworkers were instructed to do. That comes from the interviews, and I won't make express reference to it. Cullen 1 and 2 were marked restricted for internal use only. And the policy seems even not to have been disclosed to the Treasury Solicitor, because in their letter of the 9th of July 2008, they wrote they'd only become aware of the policy a short time ago.
So where's that?
It's page 801 to 2.
It's referred to in B.
Yeah, it is. I can't give you the reference, but it is in B. And there is also material that we get from the new disclosure, which assists on this point. And it's set out. It's page 3025, which tracks the changes that to proposed policy, which were being put up or being advanced in the beginning of 2008. It's the footnote on that page, footnote 17.
Page?
Page 3025. And what it demonstrates is that at that time, of Appendix 5, what it demonstrates is that at the beginning of 2008, there are various drafts going backwards and forwards, and they start off talking about amendments to the published policy, and then it seems, following intervention by Lynn Homer, they become changes to the internal policy. So somebody's clearly addressed their mind to the distinction between the two and decided not to go with publication but to go with internal. And finally, on this point, there's the evidence of what actually happened, that the practice of keeping the policy secret was successful. Nobody knew about it until the 1st of April 2008. And indeed, in the Ashori case, the hearing was conducted until the very last stages without the judge being aware of the policy. He only became aware after the judgment. Was it after the judgment?
Yes, he then reversed his judgment.
Yes, he only became aware of it after his judgment and had to reverse his order. Now, all of this is explained, and this I think is my Lord Simon Brown's point, that the eventual intention was to publish when the policy documents caught up. And that's the finding, in effect, that the Court of Appeal make at page paragraph 122. But that too is difficult to reconcile with the facts. Firstly, as we point out in our case, it was impossible for the actual policy to be published because it was unlawful. But secondly, when was publication going to happen? As I said, going through the chronology, in August 2006, the published policy was amended. It still kept the presumption. In July 2007, the Abdi case was heard. No reference there. In March 2008, the published policy was changed again. No reference except to the presumption in favour of release. So if it was simply a question of waiting to catch up, when was the catch-up going to happen? And in fact, when the policy is eventually published, on the 9th of September 2008, it's a different policy. They didn't publish Cullen. They published a policy that moved to a presumption in favour of detention. So it simply doesn't make sense to say that this is just a case of practice not catching up with publication. And even if it is, the fact that there was an eventual intention to publish simply does nothing to diminish the respondent's culpability on this point. Because the department might not have started with an intention to operate a clandestine policy, but it quickly became apparent that that's what they were doing. And at that point, they had a choice. They could either publish or bring in line with existing policy, or they could continue to act unlawfully, and they chose the latter. And they continued with the latter right up until the 1st of April. And that really brings me to the final point here, which is to do with the way in which the matter eventually came to light. Because the respondent says in her case that the true policy was voluntarily disclosed. It's paragraph 11.21. But that's true in only the most attenuated sense.
Sorry, can you just give us that again?
It's paragraph 11.21. It was true only in the sense that there wasn't actually any court order at that point. But to the extent that the respondent had any real choice in the matter, it's yet another example of the kind of cynical approach to legal processes that one sees running through this entire sorry saga. I can make the point by taking you to page 1731, which is in Appendix 2B.
Which again?
1731. And this is it starts at 1730. It's a document which is headed Actions for Unlawful Imprisonment, Abdi and Lumba, which were two of the cases joined in this group, likely disclosure of Operation Cullen instructions. And then the above-named FMPs have lodged actions for false imprisonment. In considering both actions, the courts are almost certain to require disclosure of the relevant Operation Cullen instructions in order to establish whether detention was lawful. And then paragraph 5, you've got counsel, treasury, solicitors and HOLAB agree that we're required to disclose at least elements of the most recent Operation Cullen instructions. As part of the duty of candor to the court, apart from the broader legal principle that detention policy should be accessible to the public so that individuals know on what basis they're being deprived of their liberty, the detention reviews in these cases explicitly mention Cullen, one by name, and the court will inevitably ask for more information about this policy. So what had happened was, in effect, the respondent had been caught out. Despite the attempts to not refer to Cullen in the course of the detention reviews and other documents, one had slipped through and somebody had referred to it in one of the documents. And the inevitable questions were asked. And then it says, counsel has advised we disclose in a low-key way within the broader evidence. I attach an extract from a draft witness statement for use in Abdi. Then it goes on to say, you'll note the witness statement proposes to annex the most recent Cullen instruction. The legal view is it's better to make the whole instruction available rather than extracts. In part, this is because the facts of these cases are in our favour. The two claimants have committed numerous serious offences, including sexual and violent offences, and haven't been considered for release under the Cullen criteria. This is a favourable factual backdrop to disclose Cullen, rather than in some unspecified future case where the facts may not be so much in BA's favour. But what's extraordinary about this memo is they're even discussing it. That they're even suggesting there might be a possibility of not disclosing, or that they're discussing these kind of consequentialist reasons for disclosing. And then you have at point 2, under the level of controversy, it says, our lines in response to this allegation are very clear. These people are being released because the courts have repeatedly told the government they can't be held indefinitely while awaiting deportation. Now, I don't say that that's in any way improper as a way of putting an explanation on it, but it's got to be seen in the context. It's part of a piece with the way that the respondent here treated its obligations. No, no. Yes, I'm asked to make clear that the abdi here, the earlier abdi I referred to as the A. Somalia abdi, this was the abdi who was heard before Mr. Justice Davis. Yes, and of course it's our case, WL. Lumba is WL. And so what then happens is that there's a and yes, and then one goes over to page 1736, which is 3 paragraphs, which eventually, well, not eventually, the same day, make their way into the first statement of Hannah Honeyman that was put before the court in both Lumba and Abdi. And we see that at page 1727 and 1729. And it was wrong. It could hardly be more. One looks at, it's only a short statement, and the operative paragraphs are paragraphs 4 and 5. And what Ms. Honeyman said was the defendant's powers to detain, it sets out the policy, and then it says that policy is reflected in guidance issued to staff. That guidance is set out in Chapter 55 of the OEM. It explains that whilst there's a presumption in favour of release, detention may be justified if there are strong grounds for believing a person will not comply. So it's the presumption in favour of release, the published document. Then it says that guidance has recently been supplemented by an internal process communication. And then it sets out the Cullen 2, which seek to identify those individuals who might be suitable for release, even though they would otherwise be detained under existing policy. So it's wrong in 2 critical respects. It says that the OEM, with the presumption in favour of release, still applies. That's absolutely wrong. Secondly, it says that Cullen supplements that. That also simply wasn't true. And in fact, when one looks at these 2 things together, one can see why David Wood in his report said, well, if you publish the 2 together, they don't make sense, because Cullen moderates the stricter blanket policy in force in the absence of Cullen. If you've got a presumption in favour of release, then the kind of criteria which is set out in Cullen simply don't make sense. Cullen didn't supplement the OEM. Cullen was a relaxation of a completely different, unpublished policy. And it also refers to the guidance recently being supplemented by an internal process communication. That's Cullen 2. It didn't mention Cullen 1. Still less did it mention the fact that for around 18 months prior to Cullen 1, there'd been a complete blanket policy being operated. The impression one gets is that for the last 5 days or so, there has been a very recent communication. It simply wasn't what had been going on for the last 2 years. Now, Hannah Honeyman must have known that that was incorrect, because she had been involved at the very early stages when the blanket policy was being formulated. And that's set out in our case. But even if she didn't know, the relevant parts of the statement were approved, proposed by Jackie Lutchford, the director of the Criminal Casework Directorate, that's 1730, where I started on this group of documents, and had apparently been approved by Lynn Homer. We don't know whether they were approved, because we haven't been disclosed the documents that show whether or not she did.
Were any of these people legally qualified?
I don't know. It's... Yes, whether or not they were lawyers, and they certainly had access to and were privy to legal advice. And certainly the note mentions that they've been advised by counsel, treasury solicitors and the internal advisors. That's at page 1731. 1731. It's the top line, the top line on that
Yes.
page. So it's clear that it's clear that they had access to legal advice at the point they decided to approve this misleading statement. There were then, there's never been any adequate explanation as to how it came to be that such a misleading statement was drafted and put before the court. Suggestions have been made that Hannah Honeyman was in effect out of the swim because she'd been on maternity leave. Now, we've got various points we can make about that, but whatever the position with those, is that it was approved at high level. And there's no explanation to that. And what then happens is that there's a further statement from Hannah Honeyman where she says, well, it represented my understanding at the time. And then we lead on to the statements of David Wood in June 2008 and October 2008, which is where I started going through the account. Again, this was all before the Court of Appeal, and they didn't make findings about any of this material, which the appellants say was crucial to the question whether or not the duty of candour had been discharged and whether or not this was a fit case for exemplary damages. And so that really brings us back to the beginning. I've taken you through the Court of Appeal's decision. The Court of Appeal, as my Lord Sir John Dyson pointed out, expressly approved and adopted what Mr. Justice Davis had said. And what Mr. Justice Davis had said was that he wasn't prepared to conclude that there was a conscious decision within the Home Office to operate tacitly an unpublished policy, known to be highly suspect, in the hope it wouldn't be uncovered, or if it was uncovered against a plan if the courts intervened, to present that as a reversal as being solely due to the courts or the Human Rights Act. Every material element of that point, of that paragraph, is in effect made out on the evidence which is now available. They did operate a tacit policy. It was unpublished. They did know it was suspect. It's not necessary to say that there was a covert plan, but they clearly didn't want the policy to be revealed. And they did have a plan about how they were going to deal with it if it was revealed. If the Court of Appeal had properly addressed all of this material, then it would have been bound to conclude that the department had embarked on a course of conduct which had concealed a secret and unlawful policy for almost exactly 2 years. And that's a course of conduct which merits condemnation in the award of exemplary damages, however one describes the threshold that needs to be met. And the Court of Appeal ought so to have found. And what we invite this court to do is to make a finding that that threshold condition is met, and then to remit the matter for consideration of damages, including exemplary damages, in accordance with the judgment of this court.
Remitted to whom?
Yeah, well, of course, it's subject to if we succeed on liability.
Yeah,
but
yeah. Who's to?
Well, it would. I think have to go back to
Mr. Justice Davis.
Well, to Mr. Justice Davis or another judge at first instance.
Yes.
Well, those are my submissions on the damages points. I'm conscious that I haven't gone through any of the points of difference between the parties on the working out of the exemplary damages principles, but those I suggest are sufficiently set out in our case.
Can I just ask, did anyone ever think of just challenging the Secretary of State's statement of the policy, which of course is referred to ultimately by the Treasury Solicitor? I mean, here it was in April of 2006 and onwards, making these statements and so on. Did anyone ever say, well, I mean, that is the policy, that is unlawful. Did anyone ever do that? I mean, and if not, why not?
Yes, there were, nobody did. Nobody, I think, in this room did, but there may have been other challenges contemplated. But the wording of those statements was quite careful in one sense, in that they referred to deportation, detention until consideration of deportation,
Yeah.
rather than deportation itself. Which, as was pointed out below, was nonsense in itself, because it referred to a near non-existent point in time.
So that was why it was said to be ambiguous. I mean, there were two.
No, exactly.
But one of them, at least, was regarded as potentially unlawful. Now, all I'm asking is, did anyone, after all, in one sense, the strange thing about this case is, out in the open, if you'd asked the Home Secretary what his policy was, he would have told you. But behind the scenes, they were all scurrying around, and as you say, sort of concealing things and so on. But if you'd asked him what his policy was, and if you challenged that, well, all I'm asking is, why did nobody ever say, well, that is flatly unlawful, it doesn't take account of the various principles and so on.
I'm afraid that's not a question I can answer.
The answer is it didn't happen.
It didn't happen, no.
Well, we just don't know, do we? I mean, you're relying on written records, aren't you?
Well, that's right. Yes, I'm not aware of any challenge along those lines being made either within the Home Office or outside.
For all we know, there might have been something orally, but never got written down.
Exactly.
Yes, absolutely. Sorry. Challenge of the court.
That's right. Yes. I mean, yes, I quite take that. Yes.
Yes, I'm reminded that there were various Freedom of Information Act requests which didn't produce any result. But no, there's no such challenge of which I'm aware. So unless there's any other point that you wish me to deal with on this aspect of the case, those are my submissions.
I mean, the press weren't treating the Secretary of State's statement in Parliament as ambiguous, were they? I mean, that's why the department was worried about publishing Cullen 2, because it represented a relaxation on what the press understood to be an outright ban.
Well, certainly I'm not sure that there are reports that deal with the express in those terms, although Dr. John Reed did himself write an article that gave that impression, which is it's in Bundle 2B, Appendix 2B. Sorry, I've got the wrong reference. I'll find it in a moment.
But I mean, there's something. Yeah, I mean, if you look at B75 in the B schedule, B75 in the page 137. Any mention of Operation Cullen in court gets picked up by the media, likely a fair amount of negative. The press will focus on the fact that these foreign national prisoners, albeit low risk, are being released.
Quite so, yes.
I mean, they thought the policy was no release at all.
Well, indeed, quite so. I'm not certainly the concern as far as the press were concerned was that they would latch onto any release as being something that would be.
So they understood the policy to be a blanket ban, and yet the claimants, their various legal advisors, thought that actually, on the contrary, that it was a presumption of release. Very bizarre situation.
Well, it may be that that's, in a sense, giving the newspapers too much credit for analysing what the nature of the policy is. It's clearly, from their point of view, it was a newsworthy event if anyone was released, but they they probably didn't direct their minds to whether or not there was a blanket policy or anything of that kind. I mean, it's fair to say this was something that did attract a considerable amount of press attention, and in the Express on Sunday, Dr. John Reed himself wrote an article saying that he made no apology for keeping them in prison. So it's something which... But the reality is that there are statements like that that are made for press consumption, but they don't amount to a policy. It would be quite difficult for the Secretary of State to have defended a blanket policy on the basis of an article he wrote at the end of 2006. And what was being said internally, was that when Liam Byrne made his submission to the Home Secretary, this is referenced in the case, although not this part of it, it's page 1607 to 8.
Of what?
Of Appendix 2B. It's about reviewing a position on bail policy. And the point is, at 1608, under 9, where with handling it says where individuals pass all 3 tests, I think there's a strong risk of maybe breaking the law if we don't grant bail. And then it goes on to say 4 further points are germane. At no time have we said publicly that we would detain all FMPs until they've been deported. And then there's a quote from the 9th of October statement to the House. So certainly the view that was being taken internally was that this was something which wasn't sufficient to support a blanket policy. And at the hearing before Mr. Justice Davis, and it's paragraph 121 of his judgment, page 93 of Appendix 1A, it'll also be in the core volume.
Paragraph what of his
paragraph 121 of his judgment. He records an acceptance by Mr. Tam, appearing for the Secretary of State, that publication could not properly be said to have taken place by, for example, the Home Secretary's statements contained in newspaper articles. And so, although there was a certain amount of material out there that was a pretty unequivocal statement of ministerial sentiment, if I can put it that way, there was nothing really that amounted to the kind of legal policy challenge. And certainly one can imagine that if one had gone to the administrative court with a copy of an article saying, well, this is now the Secretary of State's policy, one might have found the challenge rather difficult.
Do we have anywhere a convenient compilation of the statements made by the Home Secretary in this matter?
They were set out, they're all in the bundles, they were set out, I think, in fairly full order in the skeletons below. But again, I can see where this is leading. It would be useful for a schedule of them to be provided for the court.
And the article?
Yes.
Newspaper article?
Certainly.
Very well.
Can I then conclude with my own stock takers to the documents that I'm going to be producing? I think what I've agreed to do in the course of my submissions is an updated version of the schedule dealing with the witness statements, a chronological and updated version of Annex B, and a schedule of all the ministerial offerings on the policy, whether they're to the House or in newspapers.
And also, perhaps this is all just including what you said, that sheet with the top
yes, it is. Yes,
things which were blanked
that's the
out.
sheet, yes.
It would be very helpful to see what the headings were.
Well, certainly, we'll produce one which is legible.
Yes.
Beloff, insofar as documents were redacted, I'd be quite interested to know on what basis. Yes. We'll adjourn until 10.